prisoners temporarily on the basis of race in order to restore order. Well, there you could have the compelling justification, namely the restoration of order under those extreme circumstances, and you could say it was necessary to use the racial distinction in view of the circumstances. The law would be narrowly tailored because you were keeping the races apart temporarily, not permanently, but temporarily, just for the purpose of restoring order. Now compare that kind of a case to a situation where prison authorities were attempting to keep prisoners separate for all purposes on the basis of race. That couldn't survive a compelling justification, because why would the state be doing that? An undifferentiated fear that there might be some problem among the races is just not good enough. It doesn't rise to the level of a compelling justification. And permanent separation is not necessary to even any compelling objective that they could identify. Now, there is this question, however, in the race area. What about affirmative action? What if the government is saying, look, we're not taking race-based laws or programs or having these programs to harm racial minorities. Instead, we're adopting these programs to make up for past discrimination or to achieve the benefits of diversity. Under what circumstances are affirmative action programs okay under equal protection of the laws? Well, the big fight here at the outset is over what test to apply. Should it be strict scrutiny, just like bad form discrimination against racial minorities, as we've discussed? Or should it be some more modest kind of a test, maybe a mid-level scrutiny or something like that? Well, the court has really struggled with this because on the one hand you could say, look, there's no equivalence between a policy designed to perpetuate a caste system under racial discrimination and one that more benignly, more appropriately seeks to eradicate the effects of prior discrimination. There's just no equivalence between the two. There's a fundamental difference here between good intentions and bad. You could say, too, that when whites discriminate against themselves, since they control political power, they can always change their mind. If the majority decides on an affirmative action program and no one changes his mind, it can repeal the affirmative action program. The whites or the majority can say, we're not having these programs anymore. Whites aren't a discrete and insular minority like certain racial minorities, and so it really doesn't harm whites because on this analysis they can always take it back, so to speak. But the court, after looking at lots and lots of cases, starting with the initial case of Bakke, the University of California versus Bakke, after looking at lots and lots of cases, and after grappling with the test, whether the test ought to be strict scrutiny or something softer, the court has finally said, both with respect to state and local discrimination in the area of affirmative action, and with respect to congressional or federal programs, the test will be strict scrutiny. It will be strict scrutiny just like it's strict scrutiny for any other race-based discrimination. And the court's most recent pronouncement to this effect is the Adarand Constructors case versus Pena, where the court said that discrimination in the form of affirmative action plans, even by Congress, will be judged by strict scrutiny. Now, the reason why the court has opted for strict scrutiny is the court said that we need a very, very close look at affirmative action programs because it is a form of racial discrimination. We need a close and careful justification of these programs to make sure race is being used legitimately. And the only way we can really find out if that's the case is if we apply a strict scrutiny. So the test for affirmative action plans for state and local governments and for Congress is strict scrutiny. Now, how do we apply strict scrutiny? Well, again, strict scrutiny requires a compelling justification and a very well-tailored law. What's a compelling justification for the government to have an affirmative action plan? Well, there are a number of possibilities. First, the state could say, we want an affirmative action plan because we think the benefits of diversity, the good effects that we get from diversification, are so profound, so important, that that's a compelling justification. And we'll call this the good effects rationale. Pretty much, the court has rejected as compelling the good effects rationale. In only one case, it accepted it. And that's the University of California versus Bakke, where the court, in effect, upheld the use of race as a factor, but not a quota, as a factor in the admission of persons to higher education. And the good effect argument there was sufficient, and it was that it achieved diversity of viewpoints, generally based on First Amendment principles, a diversity of viewpoints among students in the student body in this particular educational context. And the court upheld that there, although it said it had to be tailored and only use race as a factor, not a quota, as I said. Now, you may know that the Fifth Circuit has held Bakke is no longer good law, and it had struck down a race-based admission program out of the University of Texas. The Supreme Court has refused to review that case because the particular admissions program that the University of Texas used has changed somewhat. But that issue about whether Bakke is still good law is apparently percolating around, and it will undoubtedly come back again. But in other areas, the court has rejected the good effects justification as compelling. In part, it has said, look, if you have a good effects justification, if that's going to be good enough as compelling, if all you have to do is say, look, it's a good thing that we discriminate in favor of certain racial groups because we think that we get better results in the society, that we have a certain diversity. If that's enough to sustain an affirmative action program, then there would be almost no affirmative action program that couldn't survive. So the court has rejected the good effects doctrine in other contexts. There was a case, for example, where a school system said it ought to be able to fire whites who had greater seniority in order to keep on racial minorities who had less seniority at a time when there was a need to control the budget and let some teachers go. And the reason why the state said it had to do this is that since some teachers had to go, it wanted to retain those teachers who were in racial minority classes because it wanted to have racial minorities on the faculty to serve as role models for the students. That wasn't good enough. That good effects rationale was not good enough. Now, what other reason could you have to have affirmative action programs, and will they be compelling? Well, the other reason is that you need affirmative action to make up for, to remedy past discrimination. And in some instances, the remedy argument will fly, but you have to look at it closely. First, if it's a court, and a court has already found that there's been a constitutional violation based upon race, let's say in a school desegregation kind of a case, then a court can order a remedy which takes race into account. For example, in desegregation cases, courts can order or allocate teachers or students on the basis of race, where a racially necessary remedy is tied to a proven past constitutional violation, and it's tailored to respond to that past violation, then court-ordered remedies based upon race can be upheld. Well, what about other remedies? What if not a court now, but what if some governmental agency or entity, like a police department or a fire department or a school, decided that it wanted to make up for past discrimination and it wanted to have an affirmative action program? Is that a compelling justification? Well, it depends. It depends on whether the entity is making up for its own past discrimination and not discrimination by the society at large. So, for example, if a police department wants to have an affirmative action program and satisfy the compelling justification prong of equal protection, and it wants to base its program on remedy, it must have, the court has said, a firm basis to believe that it, the police department, had discriminated against minorities in the past. Not that there was general racial discrimination in the society. If they have that, if they have a firm basis to think that they had discriminated and they were making up for their own past discrimination, then they could satisfy the compelling justification prong. Or let's say you're a legislative body, like a Congress or a state legislature. If that body makes specific findings of past discrimination in an area, or finds that its financial programs have been used specifically to prop up racial discrimination, and if it adopts legislation narrowly tailored to address those problems of past discrimination, then too, legislatures could have a compelling justification for an affirmative action program. But generally, again, making up for past societal discrimination is not adequate. Now, that's just one part of the test. Laws also have to be nicely tailored, well tailored under the strict scrutiny test. This applies to court-ordered discrimination, court-ordered remedies, and to institutional remedies. And to consider how that works, let's consider a case out of the city of Richmond, but first we'll turn over the tape.